I'm honored to be with you today. Here in Brasilia, it's 2 p.m. and I need to show my competences and qualifications. My name is André Freire. I'm an analyst, legislative analyst at the Chamber of Deputies, a lawyer and archivist, and a specialist in data protection. I served as the director of the Chamber's Documentation and Information Center for 6 years, and now I'm the technical advisory board of the leadership of the Republican Party, including the president of Consumer Protection Commission, Deputy Jorge Brás. On issues related to the general law on the protection of personal data, we are currently working on strengthening resolution number 4 of the National Data Protection Authority, which deals with the administrative and dose of punishment for those data process agents who commit illegal acts related to the general law on the protection of personal data. I'm very pleased to be participating in this panel today. It is an honor to be with such a well-qualified colleagues who are interested in studying data ownership. I would like to start by talking about the Chamber's experience. We have an open parliament, right? Most of our data is available so that society in general can access, collect, and use it for analysis by the legislative branch and for analysis of the proposal that are being processed within the National Congress and the Chamber of Deputies. This brings us great joy because the law on access to information was a pioneer in the process of the opening up data. In a very innovative way, it gave it the opportunity for the citizen to access data and use it to available public policies, and specifically in the case of the Brazilian Parliament, to evaluate the work of deputies. This is very good for us because our parliament in Brazil has the possibility to give for the citizen our data about the parliament, our legislative process, our activities of the member of parliament, and it's very innovative in the world because our open law is about the information open law is to open every data for the citizens, and the citizens can get this data and to process data with the artificial intelligence or some system, and it's possible to give for us the analysis of the legislative process, the analysis of activity of the member of parliament, and this is create the transparency and the good accountability. But we need to improve more and more and more. It's every country, every parliament, it's necessary to improve this type of behavior with the process of data. And with this introduction, I'd like to say I'm very honored to be with you today, and I will ask for our friend, our colleague from Ireland, our colleague, sorry for the pronunciation of your name.
Ciarán Doyle.
That's me. Yeah.
It's correct. Is it
Here
correct?
on Doyle. Yeah, absolutely. Very good.
Yes, Ciarán Doyle. Okay, perfect. I'm very honored to be with you today, and I will they ask for the first question about our issue. Um, Different countries are raising. Let me see. Different countries are raising significant rubs for the technology organization, such as Ireland, for example. How is your institution handling data ownership regulation, considering this context?
Yep.
This is your time is 3 minutes, and after this, our colleagues they have also 3 minutes.
Yep. Thanks, Andre. Yeah, so I've been thinking about this question in advance of meeting today, and I think Ireland and our Parliament here have been through quite a lot in terms of data, data ownership and data handling and data regulation quite recently. So I think first of all, what I'd say is Ireland, by being part of the EU, has got quite clear guidance in terms of the GDPR and what it sets out. So within that, it does clearly define data owners and data processors and their roles within that. So it gives us a pathway or a framework to work within. I'm not saying it's easy to work within it, but I'm saying it exists and it's something we can work within. And I think that helps us then in terms of how to look at and tackle our data. So we're able to say, okay, this is our data. We need to define who the owners of the data are. And then in that, we need to define who the processors of the data are. And in that, and often many of the cases, we are the primary processor. Although we'll have many owners, we're often a primary processor of data on behalf of our politicians. We are a bicameral parliament. We have members of parliament and senators. So this requires us to go through, I suppose, knowing a lot about our data across our directorates and then down at a business unit level within the Parliament. It's not an easy task, but it's definitely achievable. And we've been on quite a long road to work on that. So after you kind of recognize that and you say, well, we have legislation which clearly defines what we should be doing in terms of data management, and we know what the roles are as well, and we know what our institution looks like and where our data is and who owns it, we need to be able to then figure out what the additional things we need to do on. So a number of years ago, about 2 years ago now at this stage, we received legal advice and we got an understanding of what we needed to do with our data. Now, we were looking at this in terms of moving it to the cloud and what we needed to do to be able to move it to the cloud. But it also, I think, applies more generally in terms of that we needed to work with our users and our members to talk about how their data is classified, to talk about how their data retention periods are defined, and to talk about impact assessment for all the data sets that we carry in here, the large ones. So knowing that, it gave us a framework to go and engage with all the business units about the data they have. And that has made things a lot easier. So we've broken the data bank down into smaller parts and engaged with people that way. And we've been able to do that with all our business units. When it comes to members, it's a little bit different because we provide them a CRM, a customer relationship management solution. So we need to be very clear with them that they are being very clear with their constituents about how their data is governed in the same way in terms of classification, retention, and impact assessment. And then I suppose to wrap up, we keep a very keen eye on the things like the Schrems challenges to data law, the privacy shield being struck down, the new EU-US data privacy framework, and all of those things we keep in constant kind of eye line in order to make sure we're offering and operating our information protection solutions, things like data sensitivity labels and data loss prevention in the right way to govern the data and mind it in the correct way. So I might finish on that, André, if that's okay. I think my time is up.
Sorry, you're on mute.
Oh, very good. Okay. Thank you very much, Ciarán Doyle. Yes, I will, I will, I will make some mistake, but I believe it's better. Okay, it's very good to hear you about the your experience with the data in Ireland, and I'm very happy with the possibilities to have uh, the issue of the general law protection data, because I know the European Union has a G RD regulation, general protection data in Europe. Yes, perfect. In Brazil, LGPD, general law protection data, is the same. Our law is the similar to the law in Union Europe. It's okay. Now I will pass for the next colleague is Daniel Schuman about the same question. Please, Daniel, please comment about the question.
Thank you so much. Thank you for having me here. I really enjoyed the presentation from Ireland as well. My perspective is a little different. So I'm in civil society in the United States. The United States, unlike Europe, has a very different regime in terms of data protection. And there is also a long-standing history of laws in the United States that apply to everybody except for the Congress. So that when it comes to thinking about data ownership and data protection, it's different with respect to the legislative branch. And there is also a constitutional provision. It's called the Speech or Debate Clause. That is also viewed as protecting many of the communications for members of Congress and their staff, which makes using the cloud, for example, a bit more complicated. What we find is that there are many veto points to using more modern technologies. And unlike some other parliaments, I think the British Parliament, for example, has like their Library of Parliament helps to set their policy across both chambers. In the United States, the House does not set policies for the Senate. The Senate does not set policies for the House. They have to agree with each other, which is not that common, to set policies for the support offices and agencies like the Library of Congress and the Government Publishing Office and so on and so forth. And for some of these, not only do they have to agree with each other, but they actually have to get the president to agree as well. So as you can imagine, when you have a system where the individual members are powerful, when the information is atomized, when control is separated in this way, you largely don't have consistent rules and processes. You often don't know who the data owners are, or if you know who the data owners are, there are veto points from people who are not data owners and not necessarily even data users, but simply they have an opinion, and having an opinion is often enough. Surprisingly, information that relates to the legislative process is more open in the United States than compared to the executive branch. There is more proactive publication of information. But when you start getting into information about individuals, about constituents, it becomes very complicated. And I'll give you one example, and then I think my time will be up, and I would be fascinated to hear from others. So one role that members of Congress play is that they must help their constituents. So if someone is having a problem, they will call their representative and say, I didn't get my Social Security check, or whatever the issue might be. When that member retires, all of that constituent information goes with them. They don't take it. It's not transferred on to the replacement. So that, let's say André, you're my representative. You've decided to come to the United States. You're here in Northern Virginia, where I live. And you decide to retire and someone else is elected, and you've been helping me with an issue that I've been having. Well, that's too bad. All of my information is now lost. I have to start over again. And that's the way the process works here, is that individuals will have control over this information. And if the individual changes or the process changes, that's it. So it's a very different system than I think what the two of you were describing. So just to be respectful of my colleagues, I will stop talking now, but I would be fascinating to hear how it works elsewhere. And I'm looking forward to continuing the conversation. Thank you.
Oh, thanks so much, Daniel, about your experience in the United States. I know about this. It's very difficult to have a general law in the United States because you have a different system of government with the big enforcement of the state. Yes, and it's very difficult to have the law. I was in Boston in the last year, and I was studying about the universal basic data income. Do you know about this? UBDI, do you know? Is a very good experience in Washington with the possibility the citizens to give your data for some companies, and these companies can be used this data, and the citizen can be paid for this data. Yeah, it's very good. But about your problem, no, your country with this problem with the system and process is difficult to see the owner of the data is very serious and it's very dangerous. Yes, but it's good to see us you see us the reality of the United States. Thank you very much. I will pass for the next colleague, Monica Palmirani. Yes, okay. Okay, please, Monica, comment about the same question.
Thank you so much. So my perspective is a perspective from a European citizen, but also a researcher. I'm from University of Bologna, and I'm been working in this domain of legal open government data since 2000. So what I can say that in Europe, the community of open government data in general is very strong, starting from the 2000. But also concerning Italy, there is a great attention to provide in open data many parliamentary data, but not limited data documents. So in my opinion, the important thing is not only to provide the data, but also to have, let me say, a chain of liability of this data in order to track documents and data each other and make these data evidence or connected with the parliamentary activities. In Senate of Italy, we have an open data portal that this portal can be queryable by API, and you can download in a standard way all the bills and also many other data concerning voting, committee, member states, composition over the time. This is another very important issue, not to crystallize information in a given moment, but to have a dynamic data, because obviously the precedent is a rule fixed in a given time, and we needed to classify this data properly with the temporal information. And also the Chamber of Deputies Italy provides an open data portal as well for the same reason. And so we have a GDPR, so the general data protection regulation, but each country in Europe customized a little bit this regulation. And in Italy, the parliamentary data are considered open, also in respect of GDPR, because the public interest is more important than balanced respect to the privacy, strictly speaking. So the privacy is not a super right, but need to be balanced with other rights, like right to research or historical reasons, or by constitutional principle, public interest. And so in this case, the parliamentary data are considered an important social element for the participation. So it's true that time to time inside of a committees, we have some important regulation to not disclose information, but there's a different reason for do so. It's not a problem of privacy, but it's a problem of to have a institutional place where to mediate the political negotiation. So it's a problem of preserve a institution where the political people, the political parties can negotiate truly, and to have an output of this mediation. So this is not a problem of privacy, it's a problem of transparency and mediation and negotiation of different positions, politically speaking. So I think the problems are many. First of all, to consider the Parliamentary Act as a common goods and to share with the community for different other very high level rights, respect the privacy, strictly speaking. Last but not least, there is the so-called right to be forgotten. That is a right that we can apply to some historical events very while and not so relevant for today. But in the parliamentary domain, let me say that this is not never lose importance, because we have historical importance in any way, and also the past can teach and can provide important inputs since today. So the so-called right to be forgotten could be applied for individual citizens. In some cases, there are some documents very sensitive, but otherwise, there are other high-level principles like fundamental rights and constitutional rights that can are in the light to have a open and transparent access.
Is it okay? Can you hear me now? You can hear me now. Okay.
Yes, very good, very good. Now it's very good.
Okay. Thank you very much. I am probably in the same kind of scenario situation with Ari, because I am really not so sure how deeply and comprehensively I will be able to participate in this subject matter, simply because Namibia has indeed not enacted comprehensive data privacy legislation. So simply, however, various sector-specific laws are in place to protect, for example, the client information, including in the legal fraternity, the banking sector, and so on and so forth. So for Namibia recognizes indeed the rights to privacy as a fundamental human right under Article 13 of the Namibian Constitution. So accordingly, all persons have a right to privacy in their homes, in terms of communications and etc. But the right to privacy is also limited as required by law and in the interest of protecting the national security, public safety, the nation's economy, the health and morals against disorder and crime, the rights and freedoms of others. So for the Namibian government currently is drafting a data protection policy that, although not yet public, is kind of expected to protect the fundamental rights and freedoms of natural persons, for example, and in particular their right to privacy with respect to data processing. This law is intended to protect Namibian citizens from abuse of their personal data and also to harmonize Namibia's data protection policy and legal framework with regional and international standards to promote the free flow of personal data under conditions of assurance and trust. So as I said, I have read a little bit about other countries. I'm listening to the rest of the colleagues presenting. And of course, I think I will learn quite a lot. And as we progress, maybe we will see how I can participate and then give necessary answers to the rest of the questions, for example.
Thank you, Immanuel, Kooper, about your experience, experience of your Parliament of Namibia. And I needed to say about the very good experience to have general law protection data in your country. It's very important because you don't have any law with protection data. The government and the big companies, big techs, they have more power to control the citizen. It's the reality in every country, in every parliament, in every government, in every big tax. Yes, this is a very important thing that your parliament can be adopted. Okay.
Yeah.
Very good. I will pass for the second question with our colleague. And I will start with Daniel, with the experience of demand progress. Yes, I will ask for the following question. In countries such as the United States, the discussion on data ownership has been also widely debated. How do you think civil society organization can influence this conversation? And what are the prospects for data-related legislation?
It's a very good question, and it doesn't lend itself to an easy answer. So obviously, civil society can continue to testify and lobby before Congress. But our political system, as you know, empowers many actors to play a role in our politics, including the corporations that you were speaking of before. And our political system also creates a lot of turnover where members of Congress and staff will often leave and go to these companies that are very interested in harvesting this data. We're having a fight right now, actually, set up for the end of this year on the use of mass surveillance information. It has a vision of a part of the so-called Patriot Act that relates to, it's supposed to be about gathering foreign information about people who are not US citizens, but it's being turned into surveilling Americans as well. And there's a real fight. The national security community, the people who see threats everywhere, want all the information about everything always. And they're very powerful and well-funded. And they're in some alignment with the wealthy corporations that we have as well. So that means that there is a very strong push to not protect information, to push off efforts to regulate how emails and phone calls and information gathered by data brokers. The US government is one of the biggest purchasers of information from data brokers because it fits into the large national security posture looking all around the world. Today is the anniversary of September 11th, which was the attack in New York and DC. And the failures of the intelligence community to manage the information that they already had was transformed into a claim for the need to gather even more information. So if you're looking for a needle in a haystack, our approach is to get a bigger haystack, which doesn't necessarily make a whole lot of sense. But what that means is that when trying to, for example, harmonize the United States and the European Union in what came out of Schrems, or other efforts around protecting people's information, the so-called security concerns will often outweigh individual rights. We also have a lot of debates around encryption, for example, about how you can self-protect your information. And that too gets wound up around sort of the security issues. So the prospects for addressing these issues on a comprehensive basis seems low in the United States, at least in the foreseeable future. We'll be having ongoing fights around changing the incentives, so breaking up large corporations. There's a lot of antitrust work which relates to the desire to gather more information together. There's an effort to use the security concerns and the expiration of the upcoming law as leverage to push for more protections, which would be possible. But it's very difficult to predict whether there would be any success. I should say the final thing, many of the large technology corporations are headquartered in the United States. And of course, that also influences the political system and changes the realm of what becomes possible, because these entities don't like to be regulated and they're very well to do. So I don't think there's a great prospect, but we will keep fighting to do better, which is all that we can do. And thank you so much for the question.
Thanks so much again, Daniel. Your experience can show us the reality of the United States. We know about the difficulty to control this type of let me explain my vision. My point of view about this is that the serious. I believe the citizens of the United States likes to give the data to have a promotion or to put some specific discount in the market or in the everything. I don't know. I was with my thought in the period that I was in the Boston, and I know about this, and but there is a good point that you say is about the security. We have here in Brazil, a big problem with our authority, National Authority of Protection Data, and ANPD. This is the authority, the National Authority of Protection Data here in Brazil. The agency that control they put the regulation, they put the fiscalization and the punishment about the illegal commit in the general law protection data. And I was with the director of this authority, and I told him it's necessary to have good hackers. Well, man, why good hackers? Oh, because our hackers working in the government can be find the problem in our systems, and you can pay very good salary to these hackers, because Brazil needs to have a good protection in personal data of our citizens. It's very important to have good professionals to give us more protection. Now, with our data, mainly in the government, it's very good to share. You share with us about your experience. Okay, let's go. I will pass for our colleague again, Monica, with your experience in the same question, the experience of Italy in the same question.
Okay, thank you so much for the question concerning the role of the civil society. in open the data, or in general how to make more transparent the data concerning especially the lawmaking process. So in Europe exists a movement of open government data since the 2000s, but now we have also a directive called the Public Sector Information, emitted in 2003, recasted in 2019, that push all the institutions, the public institutions, deliberative bodies to open as much as possible information concerning the lawmaking process. And obviously, I'm not have a direct experience to open the detail by email by the members of parliament, but it's very important, in my opinion, to track the official steps by regulation of the assembly in the lawmaking system, and to understand the provenance of such amendment, for instance, who voted, which parties, also to cross these information with the election campaign. So in Italy, but also in Europe, the civil society and the civil association are very strong to monitor this consistency between for instance, the promises in the election campaign and what is voted inside of a parliament. And so to have access to this document is fundamental for monitoring that, and to return also in simplified way this information to the citizen in order to grow up a consciousness based on data about the political institution activities. But it's not limited also to the public sector information. Now we have so-called European digital strategy. And the European digital strategy is devoted to balance the data protection with other rights, including the public interest, especially after the COVID pandemic period, because in the pandemic period, all of us assisted to the fact that the lack of information very in time affected strongly the society. So the Digital Governance Act and Digital Act are the two main pillars of the European digital strategy that try to compensate to balancing the individual privacy and data protection rights with other rights. And new services are grow up, especially two kinds of intermediaries, actors, stated by Governance Act and Digital Act. So these intermediary actors can act in two different ways: as a no-profit association for the general interest, collecting data, anonymized, and to return, especially for public interest, to reuse, and intermediary for data services for commercial purposes, to collect data, to polish, to take agreements with the companies, to check the purposes if are lawful and legal, and in case to have a sort of agreement for disseminate and open these data. So this data strategy, European data strategy, is very complex, and we need to pay attention because many different perspective and purposes are combined in a balanced way. I want also to cite another important movement for us in the community, that is free access to law movement that started in 1992 in the Cornell Law School, and thanks to Thomas Bruce and Peter Martin, and it is still now a very large community over the world that push the Creative Commons license for the legislative data and parliamentary data connected with the lawmaking process. So this is a very fundamental movement by the civil society, also oriented to the companies, not only to the citizen, but in order to provide the basic ground of information, authentic, authoritative, and with a high level of integrity, to provide to the companies for develop an advanced service in the data society. So also this approach is very close to the European data strategies nowadays. So we need authentic parliamentary data, authoritative with a seal, let me say, also for new services in the market that are very traceable and reliable. So this is, in my opinion, one of a promising domain where also the data society can grow up developing advanced services.
Apologies for that. Let's start again. Yeah, look, I think it's been very interesting to hear from Daniel and Ari there just in relation to that, because I mean, I think we've all seen, you know, the big four at the antitrust hearings, you know, in Congress. Like you had Alphabet / Google, Amazon, you know, Meta, Facebook and Apple all there, and they're making lots of different arguments and points why they want to retain market share and how they go about retaining market share, and it's all about staying ahead of the pack and hoarding and harvesting data in order to allow for that, right? So if you really boil it down, I think, and that you know, and they have a huge lobby. The guys are right, but I think what's very interesting, and some of the points I've heard made alongside that are that you know, it's eminently possible to devise solutions that can take data ownership and privacy into them. Like it's just simply not a problem. You know, it's very doable. And, you know, I think the example Daniel laid out in the first contribution early on about, you know, a member retiring and having data belonging to a constituent, you know, every parliament, thankfully, or not thankfully, but, you know, has an experience of that in some way, probably. And if you blend that very practical real world problem with a process more generally understood across every organization, like joiners, movers and leavers or something like that, it's totally possible to say, this is something we can solve and fix, you know, with the appropriate processes and controls in place. We've seen that happen in sectors like the financial services sector, where regulation is far stricter because of directives in Europe, like the NIS directive, you know, Network and Information Security Systems Directive. And thankfully in Europe, I suppose what's on the way is NIS 2. And that will be a directive which takes the real heavy work laid down in NIS 1, I suppose, for financial services sectors, and begins to apply it to essential services, like which parliaments will fall into. And then you get this blend of cybersecurity, data, and process modernization all coming together. And I think it's incumbent on people looking to transform and modernize business processes to see how that blend can be worked to prove the case, to argue back against big tech and so on, to say that it's eminently possible to design these solutions, and here's how you go about doing it, and then argue that out. I'm not saying that will win the day or anything Pollyanna like that, but I think because it's eminently doable, it needs to be demonstrated and displayed. And certain institutions like parliaments using the legislation and the directives and the regulations on their way need to be able to take that challenge on and do it. Like some of that congressional stuff in the US reminded me of, you know, the big tobacco going in there. And I'm not saying these are the same things at all, but big companies where private interests and massive lobbies are at heart will always push back and push the boundaries in terms of what's right, you know, against what's wrong and what should be done. And the arc of justice or getting to the right place on these things is long and it's slow. But it doesn't mean, not that anyone here is saying we should stop and not have the argument, but because it's possible, the fight should be had, and all the tools in the community's armory should be, you know, used up and laid to bear to be able to have that fight and take it back. Because there is no way that it's not possible to do these things. It's just a case of finding the right will over time and winning the argument over time, because it won't be won quickly. Look, I'm over on my time there, André, so I'll stop there. Thanks very much.
Okay, thanks so much, Ciarán. And I will pass for our colleague, Immanuel Kooper. Please, you can answer the same question.
Yes, thank you very much once again. As I've said, I'm learning quite a lot from the rest of the colleagues, especially from the US case. But indeed, the civil society organizations in Namibia indeed plays a very significant role. They are quite good change makers. They are very much vibrant and really works with government as well. So civil society organizations, I believe, can and will better consult communities through probably public outreach programs that we do, public hearings that we know of, and also to better sensitize the communities on the importance of legislation regarding data-related issues, because I think the general data protection regulations and laws, once enacted, will provide a framework to ensure that personal information about people or individuals are shared appropriately. So through civil society organizations, I believe they can also sensitize citizens on, for example, why, what, how, and with whom information can be shared, and seek the agreements unless it is unsafe or inappropriate to do so. But one good thing, as I've earlier alluded to in the first question, is that Namibia is indeed in the right direction, that it is in the process of drafting the data protection policy. So once the policy is in place, I think all of us will be able to, us working for government and parliament in particular, will be able to then share and expand, let the citizens understand what this law is all about, so that we can take it from there. But otherwise, I think civil society plays a very important role.
Thank you, Immanuel. I will comment about the three speakers, and I guess it's very important to set up the agreement with the citizen, university, government, executive power, and legislative power, and the justice also, because and the big techs and the companies in general, because we have the same problem to control the data, to put the data to open, to access to the citizens, and we need this with the collaborative thought, the thought with involved at several areas. Yes, and okay, let's go to the next question with our colleague Monica. Monica, could you share insight on best practices or academy approaches to dealing with data ownership in Parliament? What role does academy play in this debate, in your opinion?
Thank you for the question. So starting on the point that, as I said, especially the legislative data coming from the parliament system should be public in principle, except obviously some privacy issue, but not also IPR issue like company patent information. So this is another topic, or state secrets, obviously. But in principle, the legislative workflow and the legislative process should be transparent and open. This is a contribution of the academic research to provide as much as possible tools, but also foundational, theoretical foundation for opening as much as possible in transparent way the legislative process data. From our perspective, we have implemented a standard. Now is an international standard of XML for annotating the workflow of a legislative process called Documentoso, or in English is called also legal document. Is open XML standard that the Senate of Brazil had the honor to, was one of the first that applied in Portuguese, Brazilian, the standard, thanks to our colleague João de Oliveira. And this standard is super important because we can track all the history of the document, of the workflow, of the process, and connecting network, very relevant for the meaning, all the documents, parliamentary documents with the final bill and the final amendments and the voting. So a network of knowledge that can be reused, obviously like a single document, but also the most valuable, important contribution is to create a network of legal knowledge that can be inspected and audited for everyone, and also reused. In this annotation, we found the three main pillars. One pillar is to guarantee the provenance and authenticity of the parliamentary information. So this is very fundamental. The second is to respect the sovereignty of data. So sovereignty of data means to maintain neutrality on the technical point of view. You mentioned it, Oracle or any others. So to use a standard XML means also to have a totally control on the sovereignty of data, because it's a technological neutral. And third, to guarantee long-term preservation with a solid archive data model for accessibility of this material over the time. So not only now, but also for the next generations. So this is a great contribution that also the academic community, especially the legal, XML, OASIS technical committee, steering committee are doing. And this is fundamental, especially now that we are living in AI society. I give an example. Suppose that one large language model like ChatGPT or BERT, and many others can detect automatically the parliamentary information and manipulate in such a way and return in different way without control of the provenance or control of the workflow. And it's evident that risk can happen of hallucination or fake news, or to inject other information not belonging to the parliaments. So the provenance, the traceability of these information are super important, especially now that we have these amazing tools that we can use in a good way. Another important principle is to preserve the explicability. When the data are used, because are manipulated, so the data are not per se, but are manipulated by algorithm or by visualization, we need to provide explicability, an explanation how these information are manipulated, how are presented, in order to avoid bias or a manipulation of the citizen. And this is a fundamental right also, especially in the democracy system, to give enough information concerning parliamentary data, how are used, how elaborated by artificial intelligence in case. So the contribution of academia is also to monitor that these principles of rule of law are respected and the democracy principles are not affected, and the fact-checking, evidence-based approach are used when we use the parliamentary data.
Thanks so much, Monica. Your answers about this reality are very good, because you say about the reality with the artificial intelligence. It's a very important thing that we can think about every country. Here in Brazil, we don't have any regulation, any law about the artificial intelligence. Our law is in the Congress to be in debate, and we need to have some regulation, and it's very important for every country also. Okay, as for the manual, the comment, the answer, the same question, please.
You can hear me, I believe. Yeah. As for Namibia, as I've earlier said, maybe I won't be able to share a number of best practices simply because from the government side, there is a draft law in place, which is still to be enacted. So, but I believe the private sector is doing quite well, as I've alluded earlier. The banks, the law firms, the health sector is indeed doing very well. When it comes to academic institutions, I believe they can assist in proper assessment of data protection laws and regulations. This can be done with together, of course, with the sound governance and training aspect, because government, academic institutions can give the proper training to deal with data issues. And then, of course, the response mechanism will then, at the end of the day, be in place. As I've said earlier, in Namibia, there is no restriction on the collection and processing of personal data. There are no data transfer restrictions in place. There are no data security requirements. There are no requirements to report data breaches by any individual and regulatory body. There is no enforcement mechanisms in place. And there is also no specific laws that regulate the manner in which personal data may be stored or transmitted online, for example. So all the above that I've just mentioned can be addressed in conjunction with the government and academic institutions once to have a data protection law. Once the data protection law is in place, then we can take it from there, give the necessary training, and of course, as I earlier said in the previous question, with the help of the civil society to establish and go in the right direction.
Thank you for the question. I enjoyed the presentations from our colleagues. And of course, I love Monica's reference to earlier to Tom Bruce, who of course is a giant in this field. For us, the decentralized nature of Congress provides a lot of opportunities because it's an opportunity to push different players within the system to release their information to the public. It's an opportunity to get them, to encourage them to share information with one another. So publishing as much information as possible in a structured data format, both in bulk and as well as available through APIs, collaborating with the public to the extent possible. So publish your code on GitHub. How do your systems work? Can you build something on top of it? There's great opportunity for public collaboration with civil society, with businesses, with academics, to the extent academics get into the space as well, to go and build more interesting, more complex things, to watch the data start inside and then go out and get enhanced and then come back inside and be used for another purpose. One thing that we do a lot, and we worked a lot with Ari on this, is de-risking the development of technology. So oftentimes internal players, people will want something, but there's a lot of veto points. People say, no, it's too hard, or it's not, they're funded, or they're not sure they have the legal, all sort of people always can find reasons to not do a thing. And the model that we use a lot in the United States now is those of us on the outside will build it, or build a pilot or a demonstration. Oh, we should be able to see all the hearings in one place. Congress isn't able to do it, so we will do it. And then we will show them that it's possible, and then they will build it themselves. When we go through the cycle, we call it the tech innovation cycle. We go through it again and again and again and again. And this is predicated upon having reliable access to authenticated information that uses unique identifiers and allows you to sort of put all the pieces together. This de-risking allows for the public collaboration that allows for innovation to move forward by showing inexpensive, reliable ways to make tools available to people that they wouldn't have otherwise. We spend a lot of time doing this. Our friends at Cornell at the Law View, like they started showing how to do this back in 1995 or 1994. Even building their own internet browser at one point. I think it was called Opera, but maybe no, it was Cello. So this type of behavior is probably the best engine that we've discovered for helping parliaments to be able to move forward, to get past their veto points, to make better technology available to all. So it's a great question. Thank you for asking it.
Thanks so much, Daniel. And I will pass for our colleague. I will call the correct name. Let me see. Ciarán
That's it.
Doyle.
Yeah.
I will learn in the final of our meeting. I will learn the perfect pronunciation of our name.
Andre, you're putting us all to shame by doing this in English. So thanks very much. You don't have to worry about my name at all. Thanks. Look, it's very interesting listening to this and talking about it, the topic in this format, because like I thought the points Monica made earlier there were very good about keeping the debate factual and evidence-based. That's key. And it was kind of similar to where my own thinking went on the question. But Ari definitely made a really good point as well in terms of, it's hard to get the right people, and you're battling against a kind of an infantilization of the public sector by the private sector. And it's hard to deal with that. So you've got to find civil servants who are capable, but then in it for the long term. And they also recognize their role as kind of long-term custodians of the data in the institution and the data that the institution holds, right? Because otherwise what you're dealing with is rather short-term thinking and quite influenced thinking that can be there on the behalf of the members. So you're dealing with that. But so I think Ari's really right on that point, and that's a battle in itself, and it can slow things down greatly. So you need the right people in the institutions to adopt the right mindset and play the long game on making the changes that are needed, and leverage every tool, whether it be legislative or public opinion or advances in technology, like Daniel just brought up, to prove the case and make the changes that are needed. So you're really the one being the custodian for the public in the parliament, say, rather than the member. The line I took from the question for me, which stood out most, was the last one, which is the role that academia plays in the debate, in your opinion. And I think that's where it's really key, because it's informing the debate, I think, like Monica was saying, and keeping it factual and evidence-based is the key. And with parliaments, these things are cyclical. They come up all the time, whether it be through, social change or legislative change. And you get the news cycle informing what the parliament does, and you get the parliament informing the discussion that happens in the news cycle or in the kind of current affairs cycle. So it's very important to recognize that there's lots of ins for academia and people from academia to influence the legislative cycle or to bring about legislative changes. I'm not saying it always works. I'm just saying there's defined points where people can get into the cycle, and they exist in every parliament when it comes to legislation. But there's also other avenues when sometimes the current affairs cycle or the news cycle drives the political cycle, So, but at a more basic, so that's important to recognize. And then I suppose at a more basic level, if there's a piece of legislation going through the House and the bill is there, or even if you're at pre-legislative scrutiny on a bill or something like that, where you've got the heads of a white paper for the possibility of a bill, and the department are in there and the members are in there, and you're before a committee. This is where witnesses get invited in, and academia needs to push its way in and find its way into those spaces in order to make its points, for any report that's going to be drafted by the committee. And then when a bill goes before the House or the Houses, or depending on your parliament, it's very important for academia to recognize that there's multiple points along that journey that they can influence the debate as well. There's the amendment process and contacting members and members of the opposition or whatever it may be in your jurisdiction and trying to influence, you know, in the right way. And then again, there's the fact that the bill will be topical and the Parliament will be driving the news cycle. So therefore you need to be maybe looking at current affairs programs in the region and trying to get onto those and influence there as well. Because on current affairs, you can get outside the boundaries of the Parliament and look to, you know, hold ministers or members or whatever it may be, bodies, even departments, to account a bit more in the public eye. So I think they're the really important things maybe to point out, and it's influencing the debate. That was the line I took, and that academia has a really should have a really strong role in influencing the actual debate that occurs during the parliamentary life cycle of a piece of legislation, and certainly any legislation dealing with data ownership. Sorry, so look, I'm way over on time. Sorry about that, André. I'll stop there.
Okay, thank you very much. Unfortunately, I will have finished with our meeting because our time is finished. Unfortunately, I'm very happy with this debate. I'm very happy with our discussion about several questions that involved the protection data, data ownership, and everything that we can discuss today with you, and I'm very honored to be with you today. And I will pass for the last question, and I need to ask for us. You need to straight in the answer, okay, with the reduced time, okay, because we don't have time now, and I'm pleasure, and the final my speech here is I do meet with you, and I hope that I can meet with you in the next debate or in the next country about the discussion with this legislative process and data protection and everything. Thank you very much, and I will begin with the question for the Ciarán. Okay, Ciarán, from your perspective, how do the challenges of data ownership relate to the transparency and accountability in parliaments and the governance in general? Please.
Yeah, sorry, I'm just thinking on this one. I think in relating this back to what we were talking about earlier, a lot of the data in Parliament is public, so every effort, like all the contributors earlier have said, should be made to make every piece of public data as open and as accessible and transparent as possible. That's got to be goal number one, and getting to that 5-star level of data, you know, where it's completely linkable in the best ways. You know, it's not published as static, inaccessible kind of PDF documents or whatever. It's done through APIs. It's open data as much as possible. I think that's what's really key. And then when it comes to other data sources, I think it's really important that the houses themselves, whatever parliamentary houses you have, understand how the data itself is controlled. You've got to have a sense of yourself and what your role is and what your responsibilities are, and to publish what they are internally and externally. So there's an agreement and sign up internally about how data should be governed and managed, and that you should declare that to the public and to the world and explain how you do data governance and data ownership. So it's beyond question. Because that's where you need to be. You need to be on top of your data management and your data ownership. And if you fall foul of that or make mistakes, that you can recognize that and be big enough to when the time comes. Sorry, I'm going really long here, André, so I'll finish there.
Thank you so much. And I will pass for our colleague, Daniel, please. You have the speech now.
Well, fortunately, much of what I wanted to say has just been said. So I will say, I think it's important to think about temporal, the time aspect. Some things that are private now are don't necessarily need to be private later on. So some of the internal debates and discussions can at times become available. At least in the US system, I think we need to push ownership upward at times. So right now, a lot of information is presumed to be owned by a committee or a individual, and we need to think about it on an institutional basis and to manage better on an institutional basis, and not just the House or the Senate or the support offices, but we need to think about how we manage it as the legislative branch as an institution. And I think that's where the United States has significant problems, because then it becomes difficult to figure out. You have the same type of information that's dealt differently by different players, and you want to have more consistency so that it's predictable. I think the final thing I would say is that there is great utility in doing data inventories. You should know what you have. You should ask everybody what they have.
You shouldn't believe them when they tell you, and you should dig in anyway and see what it is that they actually have. Having an assessment of what you actually hold can help set that type of policy. So thank you for the question.
Thank you so much. Daniel, you told us about the necessity to have the data mapping. Data mapping is very important for every analysis about the data. In every bank and in the process or in the system is very important. We have the data mapping. Data mapping is very important. Okay, I will pass for our friend Monica, please.
Thank you so much. So the main challenge now for reaching the transparency and accountability is to finalize the digitalization and the transformation digital way of all the activities in the parliament, because otherwise we have some spot not well with the light, the good light. So this is a very challenge to digitalize everything in order to have all the workflow digitalized. The second point is to have in mind the interoperability between the institutions, and standardization help a lot to cope with the interoperability between the data, because the data time to time are available but not mappable or not comparable in quality, in timing, or in granularity on the level. So also this is super important, because otherwise we can ask transparency, but the granularity of the data are not comparable. And so the standardization is very important. But also is emerging another goal, not limited to accountability and transparency, as I mentioned it before, the explicability. So to explain what the data are meaning to the common people, because transparent means are accessible, but maybe not explainable, and the people can understand nothing. So the new goal is explicability and explainability. And also, from my perspective, I see in my research also the emerging goal of monitoring the policies if they are matching with the legislation. So suppose we have a goal of climate change, we want to monitor if the policy is reflected in the legislation, and if the law and the parliament activities are really effective for coping with the goal of the policies. So in my perspective, there is an emerging topic concerning policies and around the legislation and the data for supporting the monitoring of the policies.
Significant? Am I audible now? Okay. I think data protection is indeed very significant, as we have seen and discussed. And therefore, if it is done, it should be necessary, it should be proportionate, it should be relevant, adequate, accurate, timely, and secure. So in other words, one should ensure that information shared is necessary for the purpose for which it is being shared, is shared only with those individuals who need to have it, and is accurate and up to date, and is shared in a timely fashion, and is shared securely. So that's what I'm basically saying, because if we do all of this, it may lead to proper governance and accountability at the end of the day. So thank you.
Thank you, Immanuel. Thank you for all. I'm very happy with this debate. I believe we had a good time to discuss about the data, about the protection data, data ownership, the regulation, the necessity to help the other countries. Yes, you need to have, what can I say? The collaboration with the countries, and we need to involve several areas in this debate. Yes, here in Brazil, we have some problems to solve, but I believe you are in the way. We are in the way, and I believe you need to take the experience with you, with several parliaments, with several universities in the every countries in the world, and I'm very happy with their experience, your experience, and very good for us to know about this reality. And I believe you construct a good way in the future. But now we need to have the hands and put in the hands in the same way to protection data, and to put the citizen near to the meaning of the data. It's very important. Thank you very much. Thank you, my friend Luis, for this moment with these people, qualified people from the every countries. Thank you very much.